Thank you, Ms. Chandralekha. A very good morning to one and all present here. The constitutional freedom of religion is the most inalienable and sacred of all human rights. Thomas Jefferson. With this quote, I would like to introduce today's distinguished guests, resource key speakers for Day 2 Plenary Session 3, theme on terrorism, religion, and national security. It's my immense pleasure to introduce Dr. Anand Kumar Tripathi, Pro Vice Chancellor, former Dean and Director, Chairperson, Center for Postgraduate Legal Studies, Rashtriya Shastra University, Gujarat. Sir obtained his BA, LLB, LLM, BPhil from University of Allahabad. He has been Assistant Professor of Law at Gujarat National Law University, Gandhinagar, Gujarat. Guest faculty in law at CMP Degree College, Constituent College of University of Allahabad. Dr. Tripathi sir has contributed articles in number of national and international journals of repute. Sir has organized 2 international seminars on Journey of Women Empowerment, Miles to Go at JNLU, Gandhinagar, and Criminal Justice System in India, Needs for Systematic Changes at Raksha Shakti University, Ahmedabad. Sir also worked as Director in Charge, Research and Development at RSU, and also worked in various capacity at various universities. He has credited quality research publication in his account. He has also worked as electronic media for fairly long period of more than 8 years at All India Radio Ahmedabad and Doordarshan Ahmedabad. Adding to his credits, Sir delivered expert lectures at various institutions including Gujarat University, Sardar Patel University, International Security Academy, Sardar Patel Institution of Public Administration, Ahmedabad, and Gujarat Police Academy. With this brief introduction, I welcome our today's esteemed guest, key speaker, Dr. Anand Kumar Tripathi. Now I request Mr. Rahul kindly to hand over the sampling as a token of respect. Welcome you, sir. Now, I also take this opportunity to introduce our own senior professor, Dr. Subramanya Godappanawar, sir, for the 3rd plenary session. Sir has completed LLB from Bellad Law College, Belgavi, LLM from Pune University, PhD from Karnataka University, Dharwad, which focused on terrorism. He has 25 years of teaching experience in law, and he has worked as lecturer and principal Law College, Bagalkot. His areas of interest include jurisprudence, interpretation of statutes, and constitutional law. Presently, sir is working as a professor in KLE Law College, Bangalore. Now, I request Ms. Chandralekha to hand over a bouquet as a token of respect. Welcome, you, sir. Once again, heartily welcome both the guest speakers to the Day 2 National Conference on Law, Religion and Society, a Constitutional Deliberation. Now I request Chandralekha to hand over this.
Thank you, ma'am. I now request our first speaker from the panel, Dr. Anand Kumar Tripathi, sir, to address the gathering.
Thank you. Good morning to all of you. Respected Professor Dr. J.M. Mallikan Vijaya, Principal, Organizing Committee members, Manoj Kumar sir, and today's guest speaker of the same session, Dr. S.C. Godappanawar, the students, and all respective members in this auditorium. When I was invited to take this opportunity for this lecture. I feel to be blessed and privileged to take this opportunity on behalf of our institution, that is Rashtriya Raksha University, an institution of national importance. The topic which was discussed with me at the time of offering invitation, I thought what to speak and how to justify this topic, because there are lot of even disputes on certain things are not clear. But I thought of this is very relevant and pertinent topic as per the changing need of the society. So first of all, I extend warm congratulations and hearty wishes to the organizing committee for selecting this topic. And this is not a very traditional topic that normally university does. They simply take it, but the way it is and the topic is selected, I am really very much impressed. Now I come to the topic: law, religion, and society. First of all, I would like to discuss regarding the object of law. Object of law is to control the behavior of the society, organization, or if any conflict arises between the party. So it is to minimize the very conflict of the society so that there should be peace, tranquility, and harmony everywhere. No conflict and no controversy should take place. If people will feel insecure in the society, then the purpose of democratic setup would be frustrated and so discouraged. So this topic, law, covers all that. Now, if I would correlate law with rule of law and rule by law. So rule of law is something that talks about the constitutionalism, constitutional ethos, and the spirit. So everything should be with due procedure of law. What is not written, what is not covered under the law is the due process. Means a common mind, application of presence of mind, application of mind should be there in executing any provision regarding the law. If you see the various provisions of the security laws, I'll be discussing this. Then, if I first come to the religion, the topic, so religious freedom should be there. If there is no religious freedom, it means that there is injustice to the society. And if there is injustice to the society, then dissatisfaction and the controversy will take place. Nobody can cause this kind of problem until you ensure that what you profess, what you propagate, what you follow, what you embrace, it should be in the hand and in the control of that person who wishes to profess any religion. There should not be any obstacle or any problem whatsoever, either from the society side, either from the other religions. What I feel, if I wish to do, that's okay. In that scenario, there would be no conflict, there would be no problem in the society. Our constitution, we have constitution experts with us also. I discussed with one of my friends. So, needless to say, 25 and 26 and so on, that religious freedom is must. In each and every religion, it gives you a lesson of peace and harmony. PBUS, if you go, the peace be upon him, and in other religions, cultural religions, Ano Bhadra Kartuventu Vishwasa, Sarve Bhavantu Sukhna, like that. So, why law is being brought into the picture? Because of this controversy, because of the human beings' emotions, human beings' even sensitiveness. That is why the problem is taking place. How this can be cut? This is the question. Subject to public order, your freedom is not an absolute right. There is reasonable restriction. There are reasonable restrictions under the Constitution. Reasonable restrictions means there is no pertinent definition of the reasonable restrictions. It depends upon the situation. It depends upon the circumstances. Say, for example, the internet facility. If I can say I have a right to use internet facility, why someone is blocking the internet facility? So situation is so warrants, the action can be taken. No black and white law can be made for any problem until you apply your mind. In Manipur case, everything is there. Law and order situation is still deteriorating and not in the control. Why? Because of certain dissatisfaction in the society. Law is there. Law is a device which will not approach everywhere. Only the mechanism of the execution of law, if it is in motion, if it is in action, then desired result can be obtained. Otherwise, it would be merely a paper tiger scheme, as I deem it appropriate. So, for religion, you respect. In a family member, the religion of respect and religion. If I am in university, I am in college, I am in a school, I must respect the others. The moment you follow this practice, profess this practice, I think you will get more response from the other side. Here, if you will not pay respect, you will not get respect. So religion is something that gives you independent right as per your style, as per your vision, your version, like that. Nobody can stop this. But on the cost of public morality, on the cost of public order, on the cost of health, if certain restrictions are imposed, like nobody can pay offer on the road, like namaz. If this situation can invite any kind of unpredictable or unwelcoming situation, then you must ask the particular community or the society to do in that manner, to do in that place, because there is every likelihood that by doing so, this situation might take place. So it is something that should be taken by an individual like Sanjaya of Mahabharata. But how people can become the Sanjaya of Mahabharata? If you have not foresight vision, like you can narrate the battle of Kaurava and Pandava sitting very far from the place, then what will happen? This more so applies with the policing also, with the police also. And when you are talking about the religion, freedom, terrorism, and national security, all are intertwined and interlinked. So you cannot separate from one issue to another issue. If religion is being discussed, it means that it will impliedly, directly may affect the very notion of the national security. So my concern is that freedom of speech is nothing but freedom to profess the religion should be given complete liberty to the public at large. Now, Why religion is sometimes related to the terrorism issue. People coined that also community, this community is known for this terrorism activities. I don't think so. It's only a matter of perceptions, matter of understanding, matter of evaluating the things by your own. So, in any law or in any provision, as I said, I know FIR provision is there. If you are agreed, you can approach police station, but discretionary power is always there. Nobody can dictate or write the law in a proper manner. As I said, until you apply your mind. In Lalita Kumari case, it was directed to all the DGPs and the police head to follow certain guidelines. So where there is gap, where there is vacuum in any provision, as per 142 of the Constitution of India, that vacuum can be bridged by the guardian of the Constitution, that is the apex court and the courts. They take lead and accordingly they move further in the direction of attaining the lofty ideals of that system. Some fanatic religious outfits are there. They are creating the problem because they consider themselves as boss of their community, of their religion. In Nuh, Haryana, in Mewat, Haryana, what is happening? It is only with this fanatic religious outfits. So for getting the political mileage, for gaining the political mileage is one of the important issues of the terrorism. Though terrorism is nowhere defined, but I am always willing to attract this community, that community, in Bageshwar Dham, in Rampal issue, in Ram Rahim issue. I am not giving the name of an individual, but if you see the politicians, they are at different. They are eyeing on that particular community. So sometimes if they are exceeding their limits in terms of maintaining peace and order, in maintaining law and order, then who will brought them on the forefront? So the political Akash, they are very much liberal. That is why religious and terrorism activities are getting height day by day. This is my traditions and cultures. If I would be that secularism, that parda, that burqa, or how to profess, how to propagate, how to follow, if this kind of instruction would be imposed on any society, people are very much inclined with their religion, their culture, their living style, their lifestyle. If I am happy, what I wear, what I can wear, if someone would say, no, you cannot wear this. So that is another issue for institution or for the school. The school can make its own rule to just control the very discipline of that particular community, that students. I am not going on that, but this is one of the important issues. Religious sentiments is also there, and if you see the explanation 1 of the Constitution of India, the wearing and carrying of tripans shall be deemed to be included in the profession of the Sikh religion. If they go, that Harmeet case, who is now put behind the bars in the Dibrugarh jail. So the situation is that you can go there, but you will consider that I will go with this sword. in all the premises. So if there is likelihood of disturbing the peace in that particular area, so your freedom and your freedom, religious freedom, would not be given due weightage and due importance because of there is likelihood of disturbance in that particular area. So restrictions is not for the cause of restrictions, but for the restrictions in terms of getting lofty ideals of the constitutional mandates. If you see the definition of the terrorism, I don't think no precise and definite definition. It cannot be covered by any scholar, but I think the deliberate use of threat of violence just to gain the attention of the political figures. What they are doing in that very remote area, far-flung area, nobody knows. But Naxalites, extremism, left wing, right wing, only for the sake of getting the cheap popularity and attention. I think media should take lead on that. If media is covering such kind of news, then their agendas and their intention would be satisfied and served. I don't think you should serve that Shraddha murder case, how it affects to the society, how religion affects the society, how media is affecting to the society. Her body was cut into 32 pieces and it was stored in the big refrigerator. The moment this news was covered in the media, most of the murders, I think, were committed in that manner. So people, they learn from the media. It will impact the mindset of the society. Those who are of unsound mind, those who are not incapable of thinking, those who are lunatic, so they would not be considered as a sound mind person. They do like that, and some psychiatric people do like that. So psychiatric assessment and that incapable of doing would be one of the important factors of causing problems in the society, whether it is religious problem. Religious problem is the doorstep of the terrorism problem. You pave way when you disturb any religion of the terrorism. This is my own understanding. Other one is that non-state actors, in order to achieve political goals, as I said, and create a broad psychological impact over the society. When you will start discussing, debating, thinking about the terrorism problem, it means that their mission is served. Their mission is achieved. Let's discuss and more even executive functionaries you must have in your mind. If you will be keep discussing on a particular topic, it will not serve the purpose and the situation will gradually become more critical, and in day to come, it won't be fulfilled. That is why international, global terrorism, good terrorism, bad terrorism, so there is no fix of it. Until you are the victim of it, you cannot pay. US, after 9/11 attack, it was experienced by the US that there is terrorism, there is terrorists, and this kind of activity can also affect the peace and tranquility of a particular nation. Otherwise, the US was feeling like nobody is ever to me. Who will take me in problem or in distress or in trouble? Who can quote me? So your problem should be considered as my problem. there is no boundary of the terror activities. You cannot fix this. Terrorism is like a cyber activity. The crime occurs in a digital platform, but you cannot visualize. You cannot see the face of that cyber substance like. So terrorism is in that manner. You cannot say terrorism might be everywhere. It is only and the feeling is that your problem should be considered as my problem. As a human being, what you deem appropriate must consider for the others in the same basket, in the same manner. Otherwise, it would be a daydream to cover all the aspects. How it came into being, Tata, everybody is well known about the fact. In Kartar Singh versus State of Punjab, Supreme Court of India maintained its constitutional legitimacy. Constitution is a guardian, and guardian always think that in what manner and how to do it. If something is written in a specific line, then it will not serve the purpose, then guardian will again think how the best outcome can be obtained. So if TADA is something that is crossing the limit of the legal boundary, then it should not be allowed on the cost of terrorism. So certain legal provisions must be accomplished and followed. So presumptions that individuals given such draconian statutory powers would act in good faith and for the benefit of public. But who apply good faith? What is good faith? If gun is loaded, if someone comes and opens fire, you do this. If any casualty takes place, people say, I did this in good faith. So due care and attention. Due care and attention must be applied not only in act of doing, but in act of thinking also. Before you consider, you cannot imagine what is going to happen. Otherwise, had you been taken the assessment of your act, this situation would not have been arose. So this is the important aspect that I would like to discuss with you, dignitaries and learned people. However, there are several examples of abuse. Abuse of laws. Unintended quota, it was also repeated because without any trial before submission of the charge sheet, person could be retained for a long duration. PUCL versus Union of India, the Supreme Court again said it has been observed that there is abuse of the statute. So for tackling, for combating the terrorism issue, the Supreme Court is somehow hesitant to repeal the laws. It means that the action is more than the requirement. Action is more than the requirement. Action should not be more than the requirement. If certain terrorism activities can be covered by using minimum force, by applying minimum standard provisions, why are you looking for the maximum one? In case of that Modi Sarnam case, Supreme Court asked only one question: why this maximum punishment? Tell me this. It could have been given one day lesser, but it was not the case. The intention was very clear, just to make that person out of the city. So this is also applying in most of the legal provisions. If police has been given the power to curb the terrorism related activities, they misuse the law. They confine the person. They never bring the reality before the public. So that is why the false cases, the registrations, that is why low conviction rate is there. From 2016 to 19, 22% of cases filed under the UAPA ended in conviction. Scientific investigation, proper methods, misuse of power, and court will rely on every aspect and everything. And this situation is so, then nothing would be obtained. Under UAPA section 15, that talks about that intent to threaten are likely to threaten the unity, integrity, and security that include the economic security of the country. So if you are involved in this kind of practice, if your practice is likely to hamper this kind of situations, then on the cost of the national integrity, sovereignty, and harmony, I don't think the law should be compromised and action can be taken. That is why it talks about the terrorist act, but not terrorism or terror. Under this UAPA, to generate the funding to participate in the terrorist organization, so many provisions are added in 2019. Because of, you can say, under which provision you will book that person. So there must be a legible provision and unequivocal provision so that situation can be tackled accordingly. And needless to inform that any state government or the local authority about the same in advance. Because earlier it was the provision that central government will inform to the state government regarding the conduction of the investigations or the inquiry. So there is problem with the coordination with the state and the central government, right? But after amendment, NIA people, they can directly go there and they are not supposed to inform to them so that the confidentiality can be maintained. So this amendment was made. Religious convergence is also one issue that may bring the problem to the society. So forceful, there may be freedom of religion, but there may not be freedom of religion by forced conversion. This is a very serious issue. I quote, everybody has a right to choose their religion, but not by forced conversion or giving invitation, justice, sharp and Himakoli. They said. Action of the state. What the state is doing? They must use the minimum force, and if anybody is involved in any unlawful activities just for collecting the funds, finance, then you have right. So IMF, this institution is banned. When any government announces that this institution is involved in terror activity, you just start seeing the reflection of the society. They start shouting, saying that it is against religion, it is against the community, it is against the society. This is for the sake of betterment of this organization. So everybody has its own even discussion points, their own sayings. So national security, if I sum up, Constitution of India is at the top, Indian Penal Code, some sections. I am not able to give you the extension of this 153A, 295A, National Security Act. It is different than the general provisions, what Constitution of India says, 22, that without any reason you will be detained, without warrant you will be detained. So because of the national security, because of the well-being of the society, Armed Forces Special Power Act, Section 3, government can declare any area disturbed area, but many people, poor people, and all the any regions, they are saying that why this upset, why this is not being refilled. Change the situation. If any area is not declared disturbed area, then army has no power to say in that particular region. That is why the public life, the public security is must, and having this utmost sincerity should be given to such people. But they are always claiming the law. Law is for the society only. Law is for the religion only. Law is for the well-being of the society. Why are you opposing law? Law cannot run. Law cannot speak. Law is lame. and law cannot run. So you ask about the problem with the law, you just tell to the educated functionaries. IT is also there. I have some suggestions. Way ahead. Combating terrorism is a joint responsibility of central, state, and local governments. If you will make any lame excuse, false charge, or any kind of situation, you will not get the proper results. This is Karnataka government issue, double engine Sarkar. So this kind of issue cannot resolve the problem. Home Minister pointing threat of terrorism has announced one NCTC, that is National Counter Terrorism Center. So this is also on the model of US, and Kofi Annan rightly remarked that respect for human rights, for combating any issues, any problem, fundamental freedoms, and the rule of law are the essential tools in the effort of combat terrorism. So terrorism, religion, and national security are interrelated and intertwined. You cannot segregate one problem with others. If you resolve one problem, certainly situation will become in your favor. Rule by law, that North Korea, you can easily understand what is going on there. What they can do, nobody can ask. Rule of law is India, what we are and what we are doing. With this note, thank you very much and namaskar.
Thank you, sir, for your valuable insights and an informative presentation. Now, before we proceed, I take this opportunity to welcome Professor Dr. Dinkar Gupte, Principal KD College of Law, Navi Mumbai, for joining us for the session. I request Dr. Manoj Kumar Vingraman, sir, to present a memento as a token of respect. We welcome you, sir. Thank you, sir. Moving on, I now request the second speaker for the from the panel, Dr. S.G. Gaurapanawar, to address the gathering.
Good morning. Respected dignitaries on the dais and on the dais. Secularism, religion, and national security. Very relevant, and 21st century belongs to terrorism. And terrorism is nothing but a politics. It's absolutely politics. Terrorism is nothing but tool of a foreign policy. Weaker section use terrorism as a proxy war. Weaker state, because they cannot declare war state of the other countries. They use the means of a terrorism to handle the problems with the other nation. That's what happening with the Pakistan and India. So they use the Pakistan as a weak country, they use the terrorism as a tool to disrupt India. So how to handle the terrorism? That's a big question. That's a big question. And the world is divided over the definition of a terrorism. There's no unanimity on the definition of a terrorism. And India, most of the terrorist legislation, they did not define the terrorism, they simply define the terrorist act. Defining terrorist act is easy rather than defining the terrorism. Because there are multiple terrorism, ideological terrorism, domestic terrorism, international terrorism. And you know, one important doctrine, it makes it very difficult to define terrorism. One person's freedom fighter is another person's terrorist. So if you identify with the victim, then the person is a terrorism, the person who inflicts the violence is a terrorism. If you identify with the terrorist, then he is considered as a victim. So a lot of problems. So handling terrorism is a politics, real politics. And I go with some of the case laws. Take the Afzal Guru case. And you are all aware who is Afzal Guru. And he was convicted by the Supreme Court, High Court, Delhi, then the Supreme Court. He was convicted and execution. Then he filed a petition before the president. And that petition was pending for a long period. 2005 he was convicted. 2014 election was due. And one party made it issue. because the ruling party at that point of time, the ruling party was the UPA government. And the opposing party was the BJP government. The BJP government made it issue that UPA government is very soft on the terrorism, very soft on the terrorism. Because 2008, the incidents when happened on the Bombay, at that time everyone thought that there would be war between India and Pakistan, but that did not happen. Even the military was ready to declare war on the Pakistan, but the political leaders did not take a daring step. Okay, so that tag was applied to the UPA government. It was very soft on the terrorism. And the BJP took the issue of this Afzal Guru case. He was convicted by the terrorist Tada. He was convicted by the High Court. He was convicted by the Supreme Court. And his mercy petition was pending before the president said it is not at disposal. Last 7 to 8 years it was pending. So it shows that UPA government was soft on the terrorism. So they made it a political issue. See how now terrorist act connected with the politics. Then now, UPA government thought that if I cannot decide this matter before the election, then definitely it backfires us. And by that time, what happened? Pranab Mukherjee had become a president. Previous president did not look into those applications. He simply sat on the applications. Next, all of a sudden, the Pranab Mukherjee took all those matters and the Afzal Guru matters, he rejected it. And he was Muslim, BJP, demanding that he must be hanged. EP was also not ready, but the circumstances forced them to execute the death sentences. Now they wanted to execute him before the elections. So there comes all, this is all mix of politics, this is all mix of politics. You know, the casualty was the rule of Allah. The casualty was the rule of Allah. You know how he was hanged? Usually the procedure, when the person was subject to death sentence, and if the death sentence is confirmed, usually he would be intimated that he will be hanged on a particular day. The family members should be intimated, and the family members should be called, and that body would be given to, handed over to the relatives. This is what the procedure happens normally, in the normal circumstances. All those procedures did not comply in the Afzal Guru case. Did not. He was just intimated yesterday. Yesterday, he was intimated, tomorrow he will be hanged. Absolutely due process of Allah was not complied. Yesterday he was intimated, and the next day he would be hanged. Definitely in violation of Article 21. And you know, they sent the intimation of his death sentences, execution of a death sentences to their relatives by a post. By a post, 15 paisa card post, not 15 paisa card post, 50 paisa packet. And that letter reaches them after 2 or 3 days. By that time, this fellow was already executed. They received the letter after the execution. Was it due process? No. Definitely, due process is openly violated, blatantly violated. At least they should have intimated. They thought that if they intimate those persons in advance, the government thought that they could take up the matter to the Supreme Court again, get clear, then it would affect the election. That was the reason why the government was in a hurry to execute him. See, politics. Politics played a very dominant role over this execution of Afzal Guru case. At least those wife of Afzal Guru, at least children of Afzal Guru, should be allowed to seek them before his executions at least once. They should have been allowed, but no. Even after death, they should have allowed him. No. And he was buried in a theater also. You are all aware the reason why he is buried in a theater. Because if the dead body was given, then the death of Afzal Guru place would become horrific, and that person's death of Afzal Guru would become more dangerous than alive. So that is why he was buried in the theater. See how the due process was sacrificed only because of a political purpose, only to meet the political ends on both sides. What is the point? So now, I'll come to another important case, Rajiv Gandhi murder case. You are aware how the ex-prime minister was killed. In Tamil Nadu, he was killed, human bomb exploded, he was killed. Then he was tried, almost all 25-30 accused were charged in that case. And it was that Tata court created a history. Almost 25 persons were given death sentence in one single murder case. It was created a history. From a Tata case, the matter went to the High Court. Then High Court, the number came down. Then from High Court, it went to the Supreme Court. Then the number again it came down. It was in a single digit. One interesting case I would like to tell you. The Tata Court has a special provision of evidences. It has a special provision of evidences. You know, you have Evidence Act, you have studied the Evidence Act, and you have studied Section 25 also. According to Section 25 of the Evidence Act, a confession made before the police is inadmissible. Cannot be accepted. And Tata, it has deviated from that rule. Okay, under Tata, any confession made by the accused to the police officer, this is Section 51, if I am not wrong, 15 of the Tata Act, empowers the police officer, and the police officer should not be less than a SP. So if a confession made before the police officer, SP, and recorded in a certain manner, that confession can be used against the accused. Under Tata, because getting evidences under Tata was difficult because witnesses are not coming forward to tell the evidences against the terrorists. So because of a threat to their life, they were not coming. So the lawmakers used these devices to handle the means of a Tata. Then matter went to the Supreme Court. The question was, killing of Rajiv Gandhi, was it a terrorist act or was it a crime? That is a basic issue. Tata court has a power to only decide a terrorist act, not a crime. There's a lot of a difference between the terrorist act and the criminal act, keep in mind. And ultimately, the Supreme Court decided that the act committed by those persons were not a terrorist act, it was a crime. It was a crime. Because they wanted to kill only Rajiv Gandhi. They did not kill, they did not wanted to terrorize the people. Their main intention was to kill them. Incidentally, the people came under some kind of fear, that's different, but they did not have an intention. They did not have deliberately created the fear factor. It is incidentally happened. So on that basis, Supreme Court said that this is a criminal act, it is a simple murder, not a terrorist act. Fine. Okay, there are some criticize that. In fact, that was a terrorist act, but ultimately Supreme Court came to a conclusion that it was a crime. Next question. Then they should have been tried under the CRPC, not under the terrorist act. Not under the terrorist act. Because the Tata Act has only power to try the terrorist act or any other matter connected with the terrorist act. Now, 1992, an incident happened. The matter reached the Supreme Court. Almost all 10 years have lapsed, and 8 years elapsed. So now the question before the Supreme Court, should it ask the trial court under the CRPC to restart the trial? So again, if it gets back to the trial court, from trial court to High Court to Supreme Court, again it will take another 10 years. Then what happened about all these things? Because so much investigation, so much trial, so much evidence, so much expenses, so much time consumption, it will be wasted. Then the Supreme Court, they convicted those persons for a murder of Rajiv Gandhi by using the confession provided under the Tata. So they used the means of a Tata, but they convicted under IPC. This is a definitely unjust procedure. The means was properly deployed. Okay, if you wanted to convict those persons under IPC, then those persons should have been tried under IPC, CRPC, not under Tata. On one hand, you say that they are guilty of a crime under IPC, but the trial you conducted under Tata Act definitely is a question about. Definitely is a question about. What is the point? So that is why, again, the Supreme Court thought that why again to give it back to trial court, again, why they waste the money. So they all talk about the expediency. Okay, they talk about all the practical, it takes a further time. So that is why it was wrong on the part of a Supreme Court. Definitely, that is not a due process. Okay, so this is one reason. Another reason, what could be the reason for the Supreme Court to go for this conclusion? Because by that time, Tata is already scrapped. Okay, there would not be any scope for instituting a fresh cases under Tata. So they thought that this could be one of the reasons. Let us go by this rule. This is one of the reasons. So here again, the due process was not complied. Okay. Now I come to one more case, important case. You know, Afzal Guru case. After Afzal Guru case, I think the most important case comes is Shankar Guru Chauhan case. What happened when the Afzal Guru petition was rejected? By that time, there were other petitions were pending before the president for controlling the death sentences. They thought that if the same thing happens to our client, then immediately they filed a petition in the Supreme Court. They filed immediately a petition in the Supreme Court saying that if the presidents reject their petitions, then they should be given sufficient time to challenge that rejection of a petition before the Supreme Court. And you are aware, when the death sentence was given, if there are delay in execution of a death sentence, you are entitled to approach the Supreme Court, and that death sentence will be converted into life imprisonment. There are so many precedents out there. Even if there is a delay for 2 years, 3 years, or 4 years, your death sentence will be converted into life imprisonment. Well established principles. And that was denied in the Afzal Guru case. Had it been allowed in the Afzal Guru case, because in Afzal Guru case, there was 2005 to 2014, 13, 7-8 years delay was there. Definitely, had it gone to the Supreme Court, his application would have been accepted and his death sentence would have been converted into life imprisonment. So that right was deprived in Afzal Guru case. Most important, the basic right. So that is a clear violation of Article 21, that is a clear violation of Article 14. So in this case, what I am telling, so they immediately filed a petition to the Supreme Court. If our clients are accused, mercy petition is rejected, we should be given sufficient time to challenge before the Supreme Court. So Supreme Court made it order that once the president rejects their application, say they should be intimated and they should be given 30 days. Until 30 days, they should not be executed. So let them give a chance to challenge in the Supreme Court. So as usual, President Mukherjee rejected their application and all those persons came to challenge that rejection petition in the Supreme Court. Around 12 petitions. In that 12 petitions, there were 3 petitions related to terrorist act. 3 persons were given a death sentence under the TADA or quota, I think. Then the question now, if there is a delay in execution of a death sentence, should their death sentence be converted into life imprisonment? Supreme Court said, yes, in all these cases, there was a delay, nearly about 5 to 8 years, let them give a life imprisonment. Now another issue came up here. All those petitions were not only murder under the IPC, but there are some terrorists. So even in case of a terrorist, simply there is a delay in execution of a death sentence, whether they should be given a life imprisonment. That was the issue. And Supreme Court said, yes, they are also entitled to protection of 21. So they are also entitled to get the life sentences. So they are treated on a par, they are treated terrorist and non-registered same. So the question again here, why you treat them as equal? They are unequal. In fact, they are unequal. Because there are 3 persons terrorists, others 7 to 8 persons are criminals. So in case of a criminals, convert their death sentences to life imprisonment. But in case of a terrorist who are condemned to death sentences, you are converting their death sentences to life imprisonment. What is the effect of it? Because there are section 54 and 55 IPC, the appropriate government has the power to reduce their life imprisonment not less than 14 years. Immediately after 14 years, they will be released. That is the impact. So this is what happens in that case. Most of the persons who are converted to life imprisonment, after completion of 14-15 years, they are released. Even terrorists also released. So here, terrorists and the criminals are treated equally, same. My question is that, from the beginning, they are treated differently because terrorists, you said that they are different class of offenders. And for them, you elected a different enactment. For them, you treated them a different trial. But at the end, again, you are treating on a same. This is something illogical. So it is very hard to digest it. At least keep in mind, by that act, 2013, Criminal Amendment Act was carried. And in case of a rape law, what happened? Life imprisonment means entire life behind the bar. It means that terrorist can be excusable and rapists are not excusable. Are you getting it? In case of a rape, he has to spend entire life behind the bar, but in case of a terrorist, by virtue of that precedent, now he gets the life imprisonment immediately after 14 years he comes back. Means he expects that executive should delay his death sentences. So at least as far as the terrorist is concerned, the Supreme Court should have given direction. No, in case of a terrorist act, your death sentence will be cannot be life imprisonment, but you have to spend the entire your life behind the bar. That kind of a direction would have made that judgment more appropriate. But that was again, it shows the immaturity of Indian judiciary. Immaturity of Indian judiciary. At the highest level, I'm not talking about the lower level. I'm not talking about the lower level, highest level. So here again, those terrorists, because at that point of a time, one terrorist has become a psycho, he has become insane. So Supreme Court, driven by that emotional factor and all those things, so they take it on the same path. So that's what. Now, after this Shatrughansana case, the Rajiv Gandhi murder case, they got a new hopes. Because in the Rajiv Gandhi case, what happened, even though they are convicted for a crime, but they are used by the Tata court and they are given a life imprisonment, then they filed a petition in the Supreme Court that we are also given a concessions. Now here again the politics was got in. Because the Tamil Nadu Assembly passed a unanimous motion that all those persons should be released immediately because they completed hardly 20 years by that time. Then again the central government intervened because they committed offences under TADA, and TADA was an enactment made by the central government, so they cannot be released without the consent of a central government. Politics came. So almost all, after intervention of the Supreme Court, they released, by that time, almost all they spent 28 to 29 inside the jail. See the tragedy of those persons. Simply they committed a crime under IPC, but they tried under TADA, but they spent 20 years inside the jail. Those persons who have committed a crime under TADA, tried under TADA, convicted under TADA, and immediately they are released after the delay in the execution of a death sentence. How? The two faces of the justice. So same Supreme Court, same laws. Okay, so this is what so terrorism is not as simple as a crime. So in case of a crime, political factors would not intervene. Okay, ethics would not intervene. In case of a terrorism, lot of other factors get involved. So only thing is that the judiciary should have acted objectively, okay, but the judiciary did not act objectively. And most problematic with the Indian judiciary is that our Supreme Court is unpredictable. Our Supreme Court is unpredictable. Why I'm saying so? It is unpredictable because Supreme Court acts in a division benches, and one division bench doesn't respect the another division bench verdict. So that's why it creates a lot of problems. So that's why there will be more number of cases are filed because there is confusion in the division bench. Ultimately, it has to be settled by 5 judges. So that creates a havoc and a mess in the Indian judiciary. And that doesn't happen in the American, because in American Supreme Court consists of 9 judges. They hear every case is a full court. There is not any conflict in the American Supreme Court, because every matter is heard by all the full 9 judges. But in Indian judiciary, what happens? It is heard by division benches. So the one division bench doesn't respect the verdict of another division bench. Ultimately, there will be some kind of confusion. Matter goes to the Supreme Court, constitutional benches. It has to sort out. By that time, it takes a lot of time. Because of this mess, because of this confusion, a lot of litigation files in the Supreme Court. So that's what I'm at the end of I'm saying is that terrorism is not a simple crime. It is a very complicated crime, and it involves a lot of politics, it involves a lot of ethics, it involves a lot of other things. So at least now, after 2000, UP Act is amended. Now things are settled. Okay, earlier, whenever the government was changing, the policy of terrorism was changing. Simple example I'm giving you, when the quota was enacted, how the quota was enacted, you are aware. Okay, Tata was enacted by the Congress government. When the Tata was lapsed on its own, when the quota wanted to be enacted by the India government, UP opposed it. What the point? And the quota was passed in the joint session. Keep in mind, Terrorist Act was passed in the joint session, and so far in the history of India, only 3 times joint session was fought. Just imagine how much politics was involved in enacting the quota. And the same government, when incidents of this one happened, and quota was deleted by the UP government before its duration. Okay, it opposes that policy. When the Terrorist Act happened in 2008 in Bombay, the same UPA got the government fought against terrorist laws. So it is all about the terrorism. It is all highly influenced by the politics, highly influenced by the emotion, highly influenced by the feelings. So it is only judiciary can act objectively. And again, the judiciary, I told you, the biggest deficiency of Indian judiciary is that it is divided because of a division benches. With all these things, time is up. Okay, thanks for giving me the opportunity presenting my views. Thank you.
Thank you, sir, for your thought-provoking address. Here we conclude our third plenary session for the day. I now request Mr. Rahul Shivanand Sandhu from 5th year BLLB to propose a vote of thanks.
Distinguished guests, ladies and gentlemen, and esteemed participants, it is with immense gratitude that we extend our thanks to all of you for being a part of this remarkable session on terrorism, religion, and national security. Your presence and active engagement have played a pivotal role in resounding the success to this event. Your thoughtful participation has contributed greatly to the depth and richness of our discussions. A special note of appreciation goes to our esteemed speakers, Dr. Anand Kumar Tripathi, Pro Vice Chancellor, Rashtriya Raksha University, Gandhinagar, Gujarat. I request Dr. Sunita B.H. Ma'am to present a memento as a token of gratitude. Thank you, ma'am. I would also extend our sincere gratitude to our very own Dr. S.G. Gaudapnath sir, Professor, KE Law College, Bengaluru. I request Dr. Sunita B.H. Ma'am to present a memento as a token of gratitude. Your profound insights on the concepts of terrorism, procedural nuances related to due process, and the flavor of politics have enriched our understanding of the legal landscape. We extend our heartfelt gratitude to Professor Dinkar Gitte, Principal, KE Law College, Navi Mumbai, for his presence and encouragement. Thank you, sir. We extend our heartfelt gratitude to our Principal, Dr. J. M. Mallikarjunaya, Vice Principal, Dr. Anita M.J. Ma'am, IQAC Coordinator, Dr. Manoj Kumar Hiremat, sir, Teacher Coordinator for the Plenary Session 3, Dr. Sunita B.H. Ma'am, distinguished guests on the dais and off the dais, teaching and non-teaching staff, esteemed participants, and students for their active involvement. Thank you once again for being a part of the fourth plenary session of the National Conference. We look forward for seeing you again in the upcoming session. Thank you.
will request the audience to kindly be seated. We shall begin with plenary session 4 shortly. Thank you.
ಏನೋ ಕಠಿಣಕ್ಕೆ ಏನ್ ಮಾಡ್ತಿದ್ರು
ಗೊತ್ತಿಲ್ಲ ಸರ್ ಹಾಕ್ಸ್ಬಿಟ್ರು
ಚೇಂಜ್ ಮಾಡ್ತೀರಾ ಈಗ ನಾಟಕ ನಡೀತಿದೆ ಈಗ ಡ್ರಾಮಾಸ್ಗೆ
Request the students to be seated. We'll be starting the plenary session now in 30 seconds.